Hello everyone, and thank you for joining us today at the FCA Authorisation Clinic. I'm going to hand you over to my colleague Claire Sim. Over to you, Claire.
Thank you, Ali. As Ali said, my name is Claire Sim and I'm CEO of Waystone Compliance Solutions business here in Europe. The Waystone Compliance Solutions business was formed by the merger of 4 specialist compliance consulting companies from across the globe, and together we support firms in managing their regulatory risks and adhering to their regulatory obligations. We support firms in Europe, the US, the Middle East and in Asia, with services including regulatory authorization and licensing applications, through to designing and implementing compliance and risk management infrastructure and control frameworks. At Waystone, we pride ourselves on being the world's leading risk, governance and compliance firm, supporting managers with over $1 trillion in AUM. Today, we're looking specifically at the UK, and this clinic will focus on firms that operate within the wholesale investment business market and is aimed at firms that are currently operating under the umbrella of an appointed representative arrangement and who are interested in obtaining direct authorization. We hope to make this session as interactive as possible, so please do add any questions into the chat box and we'll answer them as we go through. The clinic today will be led by Stuart Holman, one of Waystone's managing directors here in London, and Stuart, along with his team, has over 25 years experience in assisting firms to obtain FCA authorization. I'll now hand over to Stuart to introduce himself to you all and to provide a brief introduction to the clinic. Stuart, over to you.
Thank you very much, Claire. So yes, as Claire says, I've been doing this kind of thing, doing FCA authorizations for 25 years. And during that time, I and my colleagues have done hundreds of successful authorizations. So the intention of today's clinic is really to be a practical walkthrough of the typical questions that firms seeking authorization are likely to ask, and the kinds of issues that new applicant firms ought to be considering when they're putting their application together. And as Claire says, it is concentrating on firms that are currently appointed representatives and thinking about direct authorization, although in many ways the process is the same for firms that aren't appointed reps. And the FCA understands that often going through the appointed rep route, becoming directly authorized is a step that many firms go through. In fact, there's one of the questions on the application is actually sort of focusing on, are you an appointed rep and now seeking authorization? So that's a very sort of a common normal process for firms to go through. I was going to start off looking at the authorization process itself. How do you file an application? If the process itself is an entirely online sort of filing, and you use a wonderful FCA system called Connect. For those of you who aren't familiar with it, it's a bit of a cumbersome system. It's not necessarily intuitive. And so one of the things that applicants need to be aware of when they're preparing the application is to understand the way the Connect system works and some of the sort of blind alleyways that it can lead you to if you're not careful. The way the system works is it asks some fairly basic questions as to what type of firm you are and sort of who runs and owns you. And that will then create in the back of the system the forms that you need to complete. It's easy, just as a warning here, it is easy to innocently and potentially even legitimately misanswer the questions, not necessarily understanding what it is the FCA is really meaning when they ask some of these questions. And if you're not careful, that then throws out the wrong forms. And if you complete the wrong forms, you're obviously going to have problems when you submit the application. So first sort of piece of advice is do be careful when you're actually completing the initial application form or questions so you can get to the forms. There are 4 stages to the filing of the application. So I thought first of all, we'll talk about the mechanics of filing. There are 4 stages. The first are what I've sort of called the corporate forms, the application by the corporate entity that's seeking the authorization. And then when they've been filed, you can see there are forms for the individuals who are running the firm, the approved persons. And when they've been filed, you'll be able to see the forms that need to be submitted for the controllers, the owners of the organization, who also need an approval. And once you've loaded up these, you're talking about 40 to 80 different documents, depending on the size of the business, potentially more than 80. That's the normal range. So it gives you an idea of how it works. And as I say, there are some blind stages, and this is again something that firms need to be aware of when they're preparing the application. You won't be able to see all the forms that you need to complete and submit until you finished the first stage, second stage, etc. So again, something to be aware of when you're going through it. And then finally, once you've uploaded all the documents, you have to pay the fee. The fee, FCA wants its money in advance. The fees range between £2,500 for advisors and arrangers and 10,000 for portfolio managers. Those need to be paid, as I say, over the FCA system when you want to file the application by debit card or credit card, Visa, MasterCard, and the FCA takes Amex, which is unusual because not everybody does. But again, it's important to understand you won't be able to actually submit the application until you've sort of paid the fee.
Fantastic, Stuart. Thank you for that. That was really helpful. You touched on there's a number of relevant forms in different parts of the application process. Does the FCA provide detailed templates and for things like such as business plans, financial projections, or do firms have to create these themselves? Can you provide a little bit of cover on that?
Of course, certainly. So yes, there are a host of forms that need to be completed, detailed forms that need to be completed, but and those will, again, the forms you have to complete will depend upon what type of license you're applying for, which in turn will depend upon how you've answered the questions in the preliminary section. So again, that's where the danger is. You can end up with the wrong forms without realizing it. As well as these detailed forms that need to be completed, two critical documents that are part of the application is the business plan and the financial projections. And there isn't a template for the business plan or the financial projections. Talking about the business plan first of all, there's some guidance in the forms as to what the regulator is looking for. So obviously you need to make sure that you're covering these. But some of the elements they want to cover aren't relevant for certain types of firms, and other bits perhaps there are extra things you should cover because of the particular business that you are. So as I say, the critical document in the application is the business plan, and time and effort spent putting it together is well worth it. It's your opportunity to set the scene, to present the story of the background of the firm and the people who own it, the people who run it, what it's doing and where it's going. It also gives you the opportunity to address some of the specific questions in other parts of the forms in the context of the business plan. So it's an opportunity, to say, to in the round put together the story of the firm and what it's seeking to do. It also is the place where you can address regulatory issues that have been identified, again, in the context. So it's your opportunity to answer questions and think about and explain issues that in relation to your particular application in the context you want to do it, rather than just having to answer ticking a box in a form or something like that. And a comprehensive business plan, it really has two great benefits. The first, it helps the FCA. If they receive this and can read and understand it, it gives them a good understanding of where the applicant fits into the market and where it's going. It also helps the firm and its internal stakeholders, because if you've got anything other than a very simple firm where perhaps more than just owner managers, it also is the one document that everyone concerned with the firm, and if it's part of a group, everyone within the senior management of that group can be expected to read and understand. So that way it enables the firm and all the stakeholders within it to ensure that the nature of the application, what's being sought, is actually clearly set out and agreed by anyone at this stage, so that there can't be any sort of questions or doubts later. In terms of the business plan, you ought to sort of tell the story, put the background of the firm, set out its ownership structure, where it fits into that structure, set out the management structure, explain the governance arrangements, who's responsible for what their roles and responsibilities are, and their relevant sort of experiences and why they're suitable for the roles. So again, it helps to set the scene for all of this, and also identify what the other roles within the firm, not just the approved roles, but also the certification functions. Going on, that it's also then important to explain the services that you're going to be providing, advising, arranging, dealing, whatever it is. Explain the target market that your service is for and why what you're doing is suitable for them. Talk the regulator through the marketing plan. Go through a customer journey. One of the things the regulator is very keen on is explanations of customer journeys. Explain the instruments you'll be trading, or the markets, or the strategies. And present an analysis of all those different activities and how those translate over into the regulatory permissions that you're seeking, so the regulator can see that you're asking for the right permissions and you're not asking for ones that you don't need. Also, it probably helps to explain, clarify the things that you're not going to be doing. So again, the regulator might have questions in their minds when they're reading this, things like, no, we're not having retail clients, or we're not dealing with listed, or whatever it might be. It will help them to effectively have an answer to a question before they even need to ask it. It's also important to describe any unregulated activities that you're planning on conducting. Explain why they complement and why they don't conflict to the regulated activities you're seeking authorization to perform. And then finally, explain your longer term plans so the regulator knows where you're going. Is it going to be more of the same? Is it going to be an expansion mode, or even potentially would you be asking for further permissions in the future?
Stuart, a quick question for you related to that. So the business plan clearly is a very key element here of the authorization process. So the more complicated and complex the activities the firm wants to undertake and the permissions being sought, the more complicated the application process is inevitably going to be. Can firms therefore apply for a more basic permissions at the outset and look to add on additional permissions once authorized?
And it's a very good question. So there's an issue here that needs to be faced. The regulator does not like firms applying at a low level because they think that's going to get them an easier ride, and then immediately, once they're in the club, as it were, try to get a broader set of permissions. So that's an important thing to remember when you file an application. However, the regulator certainly is very sort of familiar with and understands why firms might want to start at a lower level, get themselves properly established, get themselves sort of the business with some kind of a proper foundation, and then build on once they've got that. But we're talking, the regulator doesn't like people to change or seek to change their business model in at least the first 12 months of authorization. And when you do seek to add further permissions, that's called a variation of permission. That in itself is a process that the FCA can take 6 months to process. So that's one of the reasons why in your business plan, at the end of it, you talk about your long-term plans, any plan to, in the future, seek further permissions ought to be signposted there. So the regulator knows where you're going. They don't think you've misled them by applying for an advising license when really you wanted a managing one. And then when the time comes to make that variation, you've got a basis to sort of leverage off of. And so as we told you in our application, we're now coming back to add this permission or that permission.
Brilliant, really helpful, thank you. You touched on it briefly earlier, but one of the questions we often get when we're supporting firms with authorization processes is around the personnel requirements. So often firms come to us and say, we don't want to hire really expensive operation resources, compliance resources, until we have confirmation that we've been successfully authorized. Can you just walk around the FCA's expectations in this area?
Sure, well, certainly. Obviously, personnel are a critically important part of a business. You can't function without real people doing the job that they need to do. And one of the sort of tests that firms have to satisfy in order to get authorized is to ensure that they can demonstrate they have sufficient resources so as to meet the threshold condition that and satisfy the regulator. Now, resources are both financial and non-financial, and of the non-financial, you've got your systems and controls, and you've also got your human resources. So this is where there is sometimes a difficulty, because the regulator cannot authorize a firm until it's been able to demonstrate to its satisfaction that it has sufficient resources in terms of people to be able to conduct the business once they're authorized. So whilst it's possible you don't have the entire team that you want in order to sort of really run the business at full pelt, as it were, you do need to be able to identify real people with real relevant experience. that a part of the application whose CVs, whose forms, whose background goes into it, so that you've got that minimum critical mass to enable the regulator to be comfortable that they can understand how this firm would run and could authorise them. Questions that applicants generally ask are things like, now, how many people do I need? Do they have to be employed at the time? When do they have to be appointed? How much time do they need to devote to these sorts of things? And what functions can I outsource and these sorts of things? All very common questions. The important thing is to remember that when you're seeking authorization, the burden is on the firm to be able to satisfy the regulator that it meets the threshold conditions in order to enable it to be authorized. And it's also important to be aware that when you're filing an application, you are under the microscope of the regulator in a way that firms that are already regulated are not. And it's probably true to say that firms seeking authorization today have to jump higher hurdles than possibly firms had to in the past. And again, I think it's probably tacitly recognized in the industry. Firms seeking authorization probably have to have higher standards than firms that are out there in the market at the moment. So it's important to remember, if you're, when it comes to harbinging your sort of resources, you've got to realize that the regulator can only authorize you if you can satisfy them that in terms of non-financial human resources, you've got enough senior people with experience to be able to actually be authorized. So there is a bit of a chicken and egg situation there.
Fantastic. And one question as well that's come through: does the FCA perform background checks on people? You stressed how important that is. How far do the FCA take that information?
Very true. Very, very true. So the answer is yes, they do. Anyone seeking approval for a controlled function will need to submit their own sort of process for criminal records checks, but yes, the regulator does also perform background checks, and it has access to a plethora of systems and records to enable it to do so. This will covers one of the points I would make to any applicant: the importance of of disclosure of anything that needs to be disclosed. And the bottom line always is, if in doubt, disclose, because if it's a matter that the regulator has an issue with, then it's important to know about it. If it's not something they're concerned about, well, then by disclosure, you're in the clear, because the act of non-disclosure could itself be something that means that the individual couldn't be approved, not because the matter itself was necessarily such a difficult issue. It's just the fact that you didn't disclose it. That in itself could be seen as failing to meet the regulatory requirements. And of course, if that person is such a critical person to the corporate application, you could see the application itself foundering because the FCA can't authorize that individual.
Fantastic. Thank you, Stuart. And linked to the personnel question that you've just answered, are there expectations or disclosures around the ownership of the entity? So we've talked about the people that are actually going to be performing some of these key functions, but what about from an ownership perspective?
Certainly. So the people who are the controllers of the regulated firm will need to be approved by the regulator. The FCA's definition of controller perhaps is a little bit more broad than would be ordinarily thought to be the case, and certainly under company law. So depending on the type of license you're going through, the controller threshold is either 10% or 20%. And so anyone who is a controller will need to seek pre-approval on the part from the regulator. There's a detailed set of forms that need to be completed. The important thing is that full information is provided, and actually the whole ownership structure needs to be, sorry, apologies, my light on, needs to be explained to the regulator. And ultimately, the regulator will need to be comfortable they can identify who the ultimate beneficial owners of the firm seeking authorization are. And the FCA will also need to be satisfied that these are fit and proper people, that they're of substance. So the corporate application is very detailed, and it requires the provision of a lot of corporate information. It also requires the provision of 3 years of audited financial statements. That's the start. That's what the form says. In practice, the regulator can be a bit more flexible than that if it's a newly incorporated holding company or whatever. But really what they want to do is to be able to understand who the controllers of this entity are, and are they people of substance, and are they fit and proper? Are they people that the regulator would be comfortable having ownership interests of this nature of an FCA regulated firm.
And Stuart, linked to that, if kind of owners, controllers of regulated entities or firms looking to become regulated are already regulated in other jurisdictions, whether that be elsewhere in Europe, Asia, the US, does that impact the application process? Does it speed things up, for example?
Yes, good question. Well, I'll look at it on the good side. The good side is that any ownership structure that's been approved by a regulator around the world with whom the FCA has sort of a memorandum of understanding, a sort of agreement of equivalency, and that's always going to be good, because it means that we are not going to conclude that the regulator will come to a different, FCA is going to come to a different conclusion as to the fitness and propriety of this organisation to another regulator. That's the good side. The bad side is the regulator, FCA, will want to make contact with that or the other regulators around the world and get confirmation from that each regulator of effectively good standing of the organisation. And the reason for that is the regulator wants to, obviously the FCA wants to make sure that it doesn't on one day authorise a firm and only discover the next day that the SEC is actually about to close them down. So the good news is, the ownership structure is going to be good. The bad news is regulator talking to regulator can take some time, and so it can actually, you're going to get there, but it could actually slow the process down. You just have to make sure you provide as much information as possible, and if you have the kind of relationship with your regulator in other jurisdictions, you can point them to expect it and turn it around quickly. That's good. Not all regulators are like that. The FCA isn't.
Perfect. Thank you, Stuart. So for firms looking to embark on an FCA authorisation process, what do they need to think about in terms of kind of initial steps, how to approach the process, etc.?
Sure. I think the important approach is to ensure that the information you put together is as complete and robust as possible. The authorization process is not intended to be an iterative process. It's not, I'll file some forms and then wait for the regulator to ask questions. That's not the way that it should work. As I said earlier, time spent putting the information together, the application together, is time well spent, because currently, about 20% of applications as filed don't succeed. By vast majority, these are withdrawn. They're not actually sort of formally refused. And I believe probably that's because the application isn't as properly considered, put together, and as full as it really needs to be to enable the regulator to feel that they understand and got enough of the information to do their job and to authorise. So that would be sort of the key thing that I would be saying is for preparation and completeness. There's also the importance, as I mentioned earlier, there will be some issues where it isn't necessarily completely clear that the position of the firm is easily one that the regulator can accept. There you need to think about these issues. You need to think and be able to show to the regulator that you appreciate the standards that are going to be applied to you, and that you appreciate that this position, that position, whatever it might be, isn't obviously sort of a shoe-in to meet their requirements. And then in the application, explain your thought process as to why this number of people, which may be less than the regulator perhaps would otherwise expect, this number of people or these types of people are competent to do this kind of business, so that you can show to the regulator you've anticipated their questions and you've actually thought about this. It's not something that you're unaware of, and you set out your approach to it, your justification. And that also leads me on to the next thing is, in all these areas, you ought to have a plan B. If, say, for example, you're proposing to use the compliance function overseas or something like that, and we'll talk about the compliance function in a moment, you might get some pushback there, in which case you need to sort of have a plan for if they say, we love everything else about your authorization, but we don't think that's going to work. You need to have already planned for that kind of event so that you can swiftly present your backup position.
Fantastic. Stuart, we've had another question raised. So as a current appointed rep, will the authorization process be any different? And if so, how would it potentially impact the application process?
Sure. Strictly speaking, the process will not be any different. There isn't a different application process for appointed representatives as opposed to people who aren't. But of course, the fact that the firm is authorised, is an appointed representative, the company itself is known to the regulator, the people working within it is known to the regulator, then that of course will help the process of putting the information together, because the information that firms require they should already possess, and a lot of the information that a principal firm would have required in order to onboard the appointed rep is all good stuff, as it were, for putting together the application. And once again, all things being equal, it is unlikely that the FCA will come to a different decision as to the ownership, or a different decision as to the people who run the firm, or its business model to whatever approval came through when the principal firm sort of obtained the registration.
Fantastic. So, Stuart, assuming the firm has done all the hard work, it's completed all the forms incredibly diligently, its information is complete, and they've submitted their application, what happens next?
Well, then, once you've filed the application, you'll immediately get an acknowledgement of receipt by the regulator. They will then it then sort of goes into, I'm afraid it just goes into the process of behind the scenes in the regulator. So the first thing they'll do is effectively triage the application. Is it sufficiently complete for it to be able to move to the application stage? And this is one of the things I was talking about earlier in terms of, have you put enough information into the application for it to actually be regarded as one that could be treated as an application, or should it immediately be pushed back for failure to include some fundamental parts of the application? Let's imagine that's not the situation that you're in. It then sort of moves to the allocation stage, to a case officer, and I'm afraid the reality is it's sitting there moving up the pile as the cases go through. Once it's allocated to a case officer, they will review the application, and once they're in a position to do so, they will ask their questions. They will always ask questions, that's their job. It's important to, when you're putting an application together, to sort of be sympathetic to the case officer picking it up. I'm very familiar with the loading up of the forms on the Connect system, and even though I know how it all works and what's going up there, it's not very easy to actually see the way that it's all been put together. What it looks like on the other end at the regulator, I don't know. But all I do know is they do seem to sometimes struggle to actually see what's being loaded up. So trying to signposting things, put a decent index together, that will help the case officer when they're picking it up, hopefully to see, before they ask for things that are already there, they'll hopefully see that they're there. The alternative, of course, is potentially when they do ask, they say you haven't submitted X or Y. If it's there on the index, it just gives you a slightly better basis to go back and say, here you go, but actually, as you saw, this was attached to attachment number 17 or something like that, helping to sort of make sure they realise what you did submit, and that there isn't a black mark there in terms of what's missing. The questions, typically by email, the questions really fall into 3 categories. You get your clarificatory questions, even where we have tried to clarify as many of these things as possible, that you never know. The case officer may have a particular question to say, oh, can you confirm whether you're doing this or that? And most of the answer, of course, is no, but they want to be comfortable. Then you've got the missing information question. Now, of course, sometimes the information isn't actually missing, or it's something that the firm knew it needed to provide, it hadn't yet provided, or sometimes you get things, okay, you want one of those. Well, that's the first time that's ever been asked for. And then that leaves you with the final things, which are the questions of substance. Again, it's by email, typically. I'll come to that in a moment. And the regulator wants to deal with the firm that's being authorised, not an advisor. Of course, they appreciate that they'll be seeking advice from professionals, but they want the answers to come directly from the firm. They might use the opportunity to have Teams meetings with the firm, because it can and you imagine it would do. It could speed the process up. You can sort of avoid some of the exchanges of emails backwards and forwards if you have a Teams meeting and they ask a clarification question. You say, no, we're not doing this or whatever, rather than an exchange of emails. So it could be a Teams meeting. Otherwise, it's principally by exchange of email. And typically, you'll have sort of 3 rounds of questions. You have your first substantive questions. Then you have and hopefully, obviously, you've got to make sure that you respond constructively and fully to all of those. Then you'll have your follow-up. There might be a few sort of further clarification or issues in relation to your response, and then you respond to those. And then the final things ought to be, well, actually, these are the final things we need you to be able to demonstrate in order to authorize. So that's how it should work. The regulator shouldn't really have sort of different bites of the cherry. So you shouldn't have a whole questions on your marketing plan and then you answer all those, and then 2 weeks later you get questions on the AML procedure. It's not meant to be like that, but it doesn't mean that doesn't sometimes happen. So you just need to be, unfortunately, it does happen, so you need to prepare for it. And then once you've satisfied the regulator of all the different things they want, they're ready to authorize you, then they will deem the application complete, and then they'll effectively ask when do you want to be authorized, or potentially there may be things like the capital that needs to be submitted. Needs to be capitalized, and then you can demonstrate that and the regulator can authorize you. So typically it takes about 6 months from filing to get to that stage.
Superb. Stuart, that's been incredibly informative. Thank you very much. What would your top takeaways be for those on the call that are potentially thinking about going down the FCA authorization route instead of kind of the AR situation?
Sure, of course. Probably preparation is everything. Time spent putting the application together in a quality way, anticipating the regulatory questions that really ought to be clear to the firm, notwithstanding the fact they're not asked on the forms, so that the regulator can see you've considered the particular realities of your application is critical. Filing in haste, I want to get it in, I want to get the FCA's clock ticking, because I've heard they take 6 months for authorization. That way madness lies, because the regulator will simply push that back and say that no, don't get our clock ticking for want of actually you're doing your own work and preparation. So that's probably the important thing there. Preparation, identifying potential issues and saying to the regulator, I recognise the standards that are required here, and this is why I believe we meet them. So having a plan B for any of those borderline issues. Being as sympathetic as possible to the case officer that's going to be picking it up, so the application is one that they can pick up and understand and appreciate as sort of swiftly and efficiently as possible, and having as few sort of to be confirmed responses to the regulator's requirements as possible, preferably none. And as I say, particularly in things like personnel and the chicken and egg situation, you do need to have critical UK-based senior management sort of as part of the application, so the regulator can actually review real people who will be in these positions, and the positions that ultimately will determine whether the firm is compliant or not, because that's down to people rather than to forms and systems. And remember the reality that you're under the microscope, and you are really probably going to have to jump a higher bar than firms in the past, and a higher bar than actually sort of firms that are currently regulated possibly really meeting, because the regulator's gaze is not on them.
Fantastic. Stuart, obviously the appointed representative model has been around for a number of years. What would you say are some of the main advantages of firms going down the fully FCA authorised route versus that of the appointed representative?
Sure. So the appointed rep route really, it started out under the Financial Services Act in 1986, and it was very much designed for effectively tied agents selling insurance. It wasn't intended to be a sort of effective regulatory cover the way that it became. And when the FSA was established, they sort of recognised that. And when FSMA was being put together, they sort of decided, do we allow this to happen, carry on and under the radar? Do we ban it, or do we put a proper regime in front of it? And they decided that to put a proper regime and recognise what it was. And over the years, it's been a useful device to allow firms to get perhaps quicker to market, and perhaps establish the sort of the strength of their business before going through the time-consuming and expensive authorization process. There's a couple of things that sort of need to be borne in mind. The first is that any properly run principal firm will need to appreciate that the appointed representative is doing business at their regulatory risk, and therefore they need to put appropriate resources to the due diligence, the vetting, the ongoing oversight of the and the controls of the appointed representative. And they will have their own risk appetites, and that may be different to the firm's, the appointed representative's risk appetites. And so you might find a perfectly properly run principal is restricting you from doing certain things that you are prepared to do, but they're going to say, not at my risk, you'd have to be running your own firm. So often the sort of once the firm has become authorised as an appointed representative, they've got themselves nicely positioned and they can prove the business is working. Then it's a case of, I'd actually like to be in control of my own destiny, responsible to the regulator directly. And that's a high bar, but I would rather have that responsibility rather than effectively having somebody else telling me what I can and can't do. There's also the truth that if you haven't got your own authorization, then you are dependent upon the good standing of your principal firm. And they may or may not have regulatory issues themselves. If they've got a lot of appointed representatives, that they can have problems, and then that can affect the principal firm and potentially then affect yourselves. So it's one of those things where it's a potentially a useful first step, but if you want sort of control of your own destiny, then direct authorization is required. It's also we appreciate that there are costs involved in being regulated, but with the degree of heightened supervision, I don't think it's inappropriate, the heightened supervision over the appointed representatives market. The regulator is expecting principal firms to do so much more, sorry, my apologies, so much more for their, in terms of their oversight. That takes time and therefore resources and therefore money. So the costs for being an appointed representative are higher than they perhaps used to be. So in a way, I look at it a little bit like, do you want to rent or do you want to buy? Yes, buying's expensive, but you're not just paying a monthly rental fee, you're actually building a business. So that's how I would see it. If you want the business to grow, it really ought to grow under your own control and direction.
Thank you. And finally, you touched on earlier in some of your earlier responses that there can be 40 to 80 different forms, etc., that need filling in. There's, it does take a lot of work to make sure that the application is organised, it's complete, it's sympathetic to the case officer. Would you say that's some of the added value and guidance and support you can get from using the likes of yourselves to support this process versus doing it internally?
Yes, I think it is. There's quite a lot of arcane knowledge in the application process that a very well-run firm who knows its business will perhaps tear their hair out over, or waste unnecessary time. So there are certainly efficiencies that can be sort of drawn from using someone who's familiar with the whole process. There's also the ability to perhaps identify where there are issues that the firm thinks go without question. There's not an issue here, but actually based upon the experience of the advisor, so actually the regulator doesn't like this kind of thing. So again, being aware of any of those pitfalls, having those pointed out, and having a guidance on how it should be approached may also be of assistance to firms. There's also most firms don't require their own full-time dedicated independent professional compliance officer, at least in the startup phase. So again, you're going to probably want to allocate responsibility for compliance and AML to one of the firm's senior managers. They're going to need support. They're going to need to be able to demonstrate to the regulator that they understand what that means. You need to explain to the regulator that all the reasons why it isn't necessary to have your own fully sort of fledged dedicated compliance function at authorization. Again, that's probably something that a firm that provides these kinds of services is best able to help you to articulate. It's also important that you're able to demonstrate to the regulator that even though you don't have a fully functioning compliance function at authorization, the compliance function is itself effective. It meets the requirements, and again, that's where having a firm that is experienced in these areas helps you to put the application together, and obviously helps you to put the structure together that's going to involve their support going forward. Helps the regulator to be comfortable that okay, they haven't got their own compliance function, but they do, and they have demonstrated the necessary commitment to employ a firm that does have the necessary knowledge and can support them. That's all part of the sort of the process of demonstrating to the regulator you've got adequate resources, which includes, if you don't have your own full-time dedicated compliance function using professionals like ourselves and other firms.
Brilliant. Stuart, thank you. It's been incredibly informative. We've had quite a few questions come through in the Q&A that we haven't been able to get through. We will make sure that myself and Stuart do reach out to anybody that we've not been able to respond to directly. So rest assured we will get back to you, albeit on more one-to-one basis for some of those questions. Stuart, thank you very much. Our email addresses are available. If anybody has any further questions, please do not hesitate to reach out to either Stuart or myself, and we'll be delighted to answer any further questions that you may have. Thank you very much for joining our FCA clinic.
Thank you for listening.
Thanks, everyone.